Hello, everybody, and welcome to my live for today. Happy Valentine's Day. I'm not sure what other countries celebrate it, but wherever you happen to be, happy Valentine's Day. So, what are we going to talk about today? Well, I'd like to talk a bit about the permission to re-enter and when you're supposed to file it, and more or less why you file it. Okay, there's some misconceptions of when it's needed and why it's needed, and so I'll like to explain that, clear that up, and get some of these misconceptions out of the way. And so then what I'll do is I'll answer your questions after, whatever questions you have, for as long as I can, and then I will say adios amigos. Okay, so let's get into it. What is the permission to re-enter? Okay, people look at various things on the internet or whatever. They have people tell them, they go, well, I have to file an I-212. Okay, so when do you have to file the permission to re-enter? First and foremost, you have to have a deportation order. If you don't have a deportation order, there's no need to file an I-212. There's no reason it won't be adjudicated. There'll be no reason to adjudicate it, okay? You could be inadmissible, for all kinds of reasons, crimes or whatever. But inadmissibility has nothing to do with a deportation order. I mean, a deportation order could make you inadmissible, and so in that respect, it has something to do with it. But once you receive the deportation order, the normal procedure is you are barred from coming back in for a certain number of years. And it depends why you receive the deportation order. If you're an aggravated felon, then it's for life. But let's assume that that's not the case. And let's assume that the normal, usual bar exists, which is 10 years. Okay? That's about 10 years. So first, let me get the misconception out of the way, because it's funny. Some people think that, okay, well, you get a deportation order and you just stay in the U.S. and don't do anything for 10 years with immigration, then magically the deportation order disappears. And that's not the case. You have to actually leave the country for 10 years in order for the deportation bar to disappear. I have other people who do leave and who wait years and years and years and years, and then they say, hey, I've waited like 7 years. Can I do a 212 now? Permission to re-enter. And I tell them, well, the answer is yes, you can, but you could have done it 6.5 years ago. Okay, the law is that the moment, this is the reality, the moment you get a deportation order, you can begin the I-212 the day after. Okay, I'm not saying it's easier or harder to get approved if you start way after, immediately after, but it's certainly doable. So if you get a deportation order from a judge, or you get removed while trying to enter, things like that, or you voluntarily leave, but you voluntarily leave because you have a deportation order, then all those instances you need the permission to re-enter. Now, another thing that I need to make clear is, let's say you file the permission to re-enter and it's approved. Some people think that with the immediate approval of the I-212 that they can just hop on back in the country, and that's not the case. Okay, what it does is it gets rid of the deportation bar. Essentially, it says, okay, it's the government saying, okay, we understand that you are normally not supposed to come back for 10 years no matter what, but because you filed the permission to re-enter, the I-212, and you convinced us, we're going to say, forget about waiting the 10 years, no more deportation bar. But it doesn't mean come right back in the country. It means you still have to do what you have to do to get a visa or a green card or whatever you have to do to get back in the country. So that's just one less step. One less hurdle that you have to do, okay? Now, if you're inside the U.S. and you have a deportation order, and let's say you married a U.S. citizen and you have to consular process, you can do the permission to reenter while inside the U.S., have that all go through, then do what's called the provisional waiver of inadmissibility if you happen to be unlawfully present, so that when you leave the U.S., you will then not have a deportation bar and you will not be inadmissible because you have the waiver. Okay? All that makes sense? So that is basically, in a nutshell, what the permission to reenter does. And again, no need to wait. If you're ordered deported and you have a way of getting back to the U.S. through a petition or through some other means, then you can do the permission to reenter right away. And to make clear, even if you don't have a way to get back, okay, let's say you're deported and you have no way of getting back, but you still, don't want to wait the 10 years because maybe something will come up. You still can do the permission to reenter the very day after the deportation order. You can do that. Okay? So that is the summation of when you can file permission to reenter and the basic law under the permission to reenter. Okay? So this is when I will scroll back and just see if we have any questions. It's going to be a relatively short live today because I have some meetings and so forth I have to get to, but at least I'm able to impart this particular thing on the permission to reenter. Okay. How is everybody doing today? I'm scrolling through the names to just see if I have any questions, and that's when I ask how everybody's doing. We had so much rain in Los Angeles yesterday. I couldn't even cross the street without going through pools of water. I had my waterproof shoes on, but they weren't 100% waterproof, I can tell you that. Okay, let's see. Just a minute. Sometimes we don't have that many questions. I mean, it is Friday. It is Valentine's Day. Sometimes people don't want to ask a lot of questions on days like today. Sometimes they do. So let me just keep scrolling here. Okay, here's one. I am Uzbekistan. Am I allowed to visit the USA and Afghanistan afterwards? Okay, well, first things first. I have no idea if you can visit Afghanistan because I'm not an Afghani immigration lawyer. You're going to have to contact someone there. But as far as the U.S., you need to get a B2 visitor visa, okay? And in order to get the B2 visitor visa, you need to prove that you intend to go back to Uzbekistan after you visit the U.S. because they're presuming that you're not going to and you're going to stay in the U.S. for the rest of your life and die here. Okay, so you have to have that non-immigrant intent, prove you plan on going back, whether it's through, a job you have waiting, property, family, whatever. Okay? Thanks, conservative. You just got the #1 gifter badge. Okay, just a minute. Again, all I did was click a little scroll and it just scrolled all the way down. Just a minute. Okay. How long USCIS usually takes to make a decision after the interview for 45? So you have an adjustment. You filed, okay, with USCIS, and you're wondering how long it takes to essentially get an approval. It depends. It depends what preference you are. It depends on how you're qualifying for adjustment, employment or family-based. But I can tell you on average, once you file that, you're looking at about 6 months to a year. Give or take. Okay? That's assuming everything goes smoothly. All right. Thanks, Anika. You got the #1 gifter badge now. Okay, let's see. Let me keep scrolling. All right. I think we got to the end here. So, wait, question just popped up. Once you get a work permit, how long before you get the green card? Well, that entirely depends on what basis you're getting the work permit and on what basis you're applying for the green card. Okay? I mean, you could tell me you're getting a work permit based upon asylum, and I could tell you, they're not going to have an interview, and you're not going to get the green card if it's approved for another 8 to 10 years. Okay? But if you married a U.S. citizen and, there's no visa waiting time, once you get the work permit, you're looking at about 9 months to a year. Okay? So that's for Maria. Just got the number 1 gifter badge. My wife won't file taxes together to remove my condition. Is it a big issue? It's an issue. Okay, immigration thinks everybody's lying about everything. So the first thing they're going to think is that you're not really married for love, because why wouldn't your wife file a joint tax return with you? I mean, what reason is it that she's not doing it? And then if I were the officer, I'd be looking further. I'd go, well, if she's not filing joint taxes, do you have anything other jointly together? Are you living together? Do you have kids? Have you commingled your funds? So yeah, it's a significant issue. And you're asking if it's a big issue, and yeah, it's a big issue. There should be no realistic reason she doesn't do it. Okay. And if there is a reason, it should hopefully have nothing to do with the green card. Okay. Let's let's see. My uncle went to Palestine to participate in the Islamic Jihad. Is he eligible for an American visa? Well, I mean, that depends. Okay. Depends what kind of visa, but moreover, the U.S. is going to, there's going to be officers that are going to claim that he's part of a terrorist organization, okay? That's what they're going to claim. And so he's going to have to prove he's not. He's going to have to prove that he has nothing against America type thing. And then prove all the other various items necessary, and that assumes it's with a visitor visa. Hi, do you know about advanced parole? Well, of course I do. I'm an immigration lawyer, and I'm a certified immigration specialist with 30 years experience. Of course I do. But the question is, what do you think you can get advanced parole from? Are you applying for adjustment of status? And are you inadmissible in any way? Are you on DACA and you think you can get it that way? Or are you on TPS? So I need to know on what basis you currently are that makes you think you might qualify for advanced parole. Because the way the administration is today, unless you are absolutely, positively, without doubt qualify, and you're not inadmissible on any other grounds, you're not going to want to do it because you'll be barred from coming back. Okay, it's from a father, U.S. citizen to son. Okay, that's a statement on an adjustment petition. I think that was filed. So, it should take, if it's a father, U.S. citizen to his son, it depends if the son's over 21 or not. Okay, that changes the preference. So, getting the work permit is one thing. Getting the green card is another. Okay? If I filed... just a second. Why does it keep scrolling up? Just a minute. If I filed my daughter as a green card I have to wait for her green card, or can I file for my citizenship? I'm not sure I understand your question. I think what you might be saying... Well, actually, I'm unclear what you're saying. I don't know if you have your green card or if you're a U.S. citizen. I don't know if you're petitioning her. So I need more information. Normally, you can file for citizenship if you have 5 years as a resident. Okay? If you're married to a U.S. citizen, it's 3. Okay? If an it's a asylee-based 485. I have an interview on February 21st. Can I expect a decision on the spot? No. You cannot expect a decision on the spot. That would not be possible, especially in immigration. Assuming that, you were granted asylum, which you must have been at least a year ago, and that you're not inadmissible on any other grounds, the decision once you have the interview should be 3 to 6 months, give or take. How long will it take to reopen an administrative closed I-485? Well, I need to know why it was administratively closed. If you're doing an adjustment, was it administratively closed because they wanted to transfer jurisdiction from the immigration court to USCIS? And if that's the case and it was transferred, why do you have to reopen it? So there's some problems in this case. I need to know what they are. Okay? Married with a U.S. citizen, have a deportation order from 2015, got the I-130 approved. What can I do? Well, that goes right within the subject of today. You have a deportation order, so you need to do an I-212 permission to re-enter to start off. Okay? First of all, no doubt. And once you do that, if it's approved, then you, assuming you're not inadmissible in anything other than unlawful presence, you can do the permission, the waiver, the provisional waiver of inadmissibility. So you have the provisional waiver of inadmissibility you do. Hopefully that get approved. Then you have the permission to re-enter that you filed, and that's approved. Then you should be able to do the consulate processing, no problem. Okay, that's for Andrew David. Got the number 3 gifter badge. Thank you. My husband has DACA. Is he safe? Well, not as safe as he used to be. If he's your husband, what's your status? Okay, are you a U.S. citizen? Are you a lawful permanent resident? You need to take care of business. Okay, the fact that you're asking if he is safe would indicate that you feel you are safe, which indicates to me you are a lawful permanent resident or U.S. citizen. So you need to get down to business, file the petition for him. If he's on DACA, that doesn't immediately allow him to adjust status. So he could do the provisional waiver of inadmissibility and consulate processing. That needs to be done. Don't wait. Okay? I mean, the answer is he's not really that safe. So if someone has a path to get the green card, don't sit there and wait because they temporarily have some kind of status that allows them to stay here. Already? Thank you, Amber. You got the number 3 gifter badge. I applied for the I-130 for my husband, my son. He's a U.S. citizen, so if I apply for benefits, can its affect... Okay, I have to sort of interpolate what you're saying here because the sentence is not complete, but I think what you're saying is if you apply... Actually, I'm unable to say exactly what you're saying. I think you're saying something about if you apply for the I-130 for your husband, is there going to be a public charge issue? Thank you for the rose. Is there going to be a public charge issue if you get benefits for your son? Okay, and there might be. Okay, it depends. I need to know what kind of benefits and so forth. Okay. Thanks again for the rose. Just a minute. Okay. Can a TPS holder get an F1 visa? I mean, the answer is yes, but I think, and you're saying the TPS won't be available this year, so I expect you're from Venezuela. The answer is yes. You can get the F1 visa, but I think what you're thinking is, can you switch while inside the U.S. from a TPS to an F1? And the answer is no. You can't get a change of status to F1, but you can leave the U.S., apply for the F1 visa, and then come back. But with F1, you have to prove non-immigrant intent, and the fact you were here on TPS for who knows how long, that might be a little hard to show. Okay, it's doable, but it might be a little hard to show. Okay. El Proco got the number 3 gifter badge. Thank you. Oh, Maria got the number 1 gifter badge. Appreciate it. Okay. You're welcome. Good morning, sir. Oh, thank you for the rose. Got a lot of roses. Thank you. I get such a kick out of that. Okay. Good morning. I have a pending asylum case since 2016, which proves my point. When someone was asking earlier how long to get the green card, depending what they apply for, you might still be waiting. Okay, you can keep waiting, or eventually, if you have a really good asylum case, file a writ of mandate against USCIS and have the judge force them to get you in so they can make a decision. What kind of lawyer are you? Well, I'm a great lawyer. But if you're asking what subject I specialize in, it's immigration law. Okay? So go ahead and ask me some questions. Yeah, I think they're talking about public charge. Well, see, I answered that. That's what I thought, but you're right. Um, okay, just a minute. Oh my God, I went to your page. Sorry. Don't be sorry. You can go to my page all you want. uh, Thanks for the heart puffs and the roses. How long? Oh, and the I don't know what that was. You're making me laugh. All this stuff you're sending me. Thanks. That's so funny. Oh, ice cream. Thank you. I'm gonna actually get ice cream today just because of you. How long do you have to wait for adjustment of status after being married to a U.S. citizen? Well, first you have to qualify. Okay. I mean, if you qualify to adjust status after marrying to a U.S. citizen and you file it right away and there's no issues, you're looking at 6 months to a year. And it depends where you are, you know? Thanks again. If you're in Montana, you're obviously going to get, if you keep sending me that, you're going to make me laugh, keep laughing. I'm going to have trouble answering questions. A chili pepper. It's funny. I mean, you might have to wait 6 months to a year. If you're in Montana, you're going to wait less than if you're in LA. Okay? That guy's funny. I have a perm bar. A judge granted me termination of removal proceedings. Can I adjust with VAWA? Well, that depends. Getting VAWA doesn't erase the permanent bar. And why did the judge grant you a termination of removal proceedings? Generally, the judge will grant a termination of removal proceedings if there is another basis upon which for you to adjust. So I would have to confirm with you because you might not have the permanent bar. Okay. RFE received 152 days ago. I-485 pending 252 days ago, or 257 days. What do I do? Okay, well, 152 days is a long time. It depends what the RFE was issued for, but assuming that you responded and you gave them everything they needed, it should be sufficient time. So, first you send in a formal inquiry, okay? So you can word it tactfully, but it's like, hello, yo, what's happening? And then do have people, if it takes long enough and they have a good case, my firm can do a writ of mandate. That's where we sue USCIS to make the decision. And I can tell you 95 to 99% of the times I've done that, it doesn't have to go to court because magically they want to settle and they want to get the decision issued. But I don't do that unless you have a really good case. So I need to know what the 485 is, what the basis is, and then why they issued an RFE. And then if you have a good case and it's pending for this long, then would be the time to do the writ of mandamus. Okay. Right. I almost have to go to my meetings here. So, what are the Chinese letters behind you? Oh, I I took martial arts for 25 years. And I became a 3rd-degree black belt. So the one like right above my head here, even though I don't know exactly what it says, I got that after I passed my 3rd-degree black belt. 3rd dan. So that's what that is. Okay. But if I was going to ask you what exactly are the Chinese letters, that I don't know. But they certainly are cool, aren't they? And the fact that I got that after I became 3rd-degree black belt makes it all the more. Okay. So that's that. All right. Well, the questions continue, but I have to sign off because I have a meeting I have to go to. So thank you for all of the presents, business mindset. It gave me a good laugh to start the day. And if I didn't get to your questions, I apologize. There's one that just came in. Let me real quick. How do I expedite my I-130 because I have a kid and alone and it's hard and I have the green card? You can't expedite because of that. Okay, you might be able to get a humanitarian parole to get the child in for some reason and then do the I-130. It might go like that. All right. And with that, I bid everybody. Oh wait. This is the guy that gave me all the funny presents. Your fees for the I-864, which is what I thought was a public charge issue, which means that you, submitted all of the necessary tax documents and all of the documents that show you won't become a public charge, I assume. And therefore, if that was the only issue, you have a good adjustment. You showed why you're not going to become a public charge. There's no need to keep waiting. Okay, do the formal inquiry, and if you don't hear in another 2-3 months, contact me. I'll let you know what's necessary to do to writ a mandamus. All right? All right. Well, everybody have a nice rest of your Valentine's Day, and don't get wet.